Hello, this is U.S. Immigration Attorney Sharifa Tharpe. Good afternoon. I'm here live to take your U.S. immigration related questions. So, I have a really good topic for you today. I'm going to talk about the biggest mistakes in the VAWA process. Now, the biggest mistake is doing it without an attorney because there are specific legal requirements that a lot of people don't know about outside of uh, describing the kind of mistreatment you're experiencing. There are other elements that you have to pay attention to. So, the other biggest mistake after that is individuals tend to underestimate the VAWA process. So, they believe that they are being mistreated, absolutely, but based on the mistreatment, you qualify, and then you don't address the evidentiary issues. So, keep in mind that there are I think the reason this is underestimated is because, starting out, you may have heard that they just take your statement, right? Your statement is your declaration, and they can accept that as evidence. And so people equate just submitting your statement alone without any other evidence as this is an easy process. And because of that, they just jump headfirst without actually taking the time necessary to put together a solid application. So that's what we make sure we do for our clients is we make sure that when we are preparing it, we are preparing everything down to the detail in a way that the officer accepts it as evidence. So give you an example of how one can really mess up um, the declaration, the statement. Now, when you're writing the statement, it's not "I was abused." You can't just state "I was abused" and in general terms state state that you were abused. You have to really go into detail and spell this out step by step for the immigration officer to accept this as evidence, because it's the way they accept evidence is any credible evidence. They're not going to just that you can't just submit your statement and expect that it's going to be accepted as evidence. The officer does have the discretion after they've reviewed the evidence to determine whether it is credible or not. And if it's not credible, then they will deny it. They will reject the evidence and they will deny your application based on a lack of credibility. So, building credibility through your detailed statement is going to be essential here. And that is one of the things that, individuals don't do. So, for example, one of the things I've seen is attorneys will let their client write the statement, and that's fine. But when the client writes a statement, they may not include the kinds of details that the officer needs, but yet the attorney may still, without doing further due diligence, may still submit that declaration when they could do a lot better. That's what my firm does is we make sure our client understands the type of detail that they need to account for in their declaration. So, for example, you have to go through specific timelines, incidents, details about those incidents. How did it make you feel? How did it affect you? Um, you know, Going through your relationship, the highlights of your relationship, whether it's a marriage, whether it's even the parent child situation, going through the best of your relationship and maybe where things changed in your relationship. Where did you start to see the red flags in your in regards to the mistreatment? What was the worst thing you experienced? How did you get out of the situation, or are you still trapped in that situation? And then you also are there are other legal requirements too that you need to address in your declaration. Your bona fide marriage, right? You do still need to show, despite the abuse, that this was a bona fide marriage. And when I say abuse, it covers mistreatment, extreme cruelty here. So, mistreatment, verbal, emotional mistreatment. It's not just about the physical here. You do not need a police report. You don't need to show injuries that you've experienced injuries from physical harm. So keep that in mind. Now, um, the other requirements here is the showing the bona fides of the marriage. So you still do have to show that you live together. You still have to show that you shared bills together. Now, and bills is not a requirement, it's an example here. One thing with VAWA though is that showing the bona fides is going to be different from marriage to marriage, from when we're talking about the marriage based relationship. Because even in these situations where there's mistreatment or extreme cruelty, the US citizen or permanent resident spouse is many times they make sure that they don't have shared bills because they're controlling. They don't want to empower their immigrant spouse, so they don't put their names on anything. They don't put their names on the lease. In cases like that, we sit down with our clients to determine what do they have to show that their marriage was bona fide, that they did live together. And there are ways, keep in mind they accept any credible evidence. So that means that it is not limited. We are not limited on how creative we can get with showing how our client's marriage was bona fide. It's just a matter of using our experience, our expertise to guide our clients to get the right evidence to submit to the immigration service. So, don't underestimate the process. Do not underestimate the legal requirements. I've even seen, for example, notarios, those who are not attorneys, they're not certified to represent anybody in the immigration process, but yet they tell people they qualify for VAWA, and they may they may qualify for VAWA, but they submit a really crappy application. And my clients, well, not my clients, but the some of my clients that have had these bad experiences, um, they end up getting denied at first because of what that notario did, that non-attorney did by submitting a really crappy application. So do not underestimate the VAWA process because you some many times you have one shot, right? And it's very hard to fix a complicated application where you've gotten a denial based on credibility. Um, so that's one. Waiting, another one with VAWA is you wait too late. You wait too late to apply for VAWA. Um, Now, when I say this, you've seen the warning signs before, and you still go forward. You may be going through the process with your citizen or resident spouse. You see the warning flags, the red flags. You experience the mistreatment and the abuse, but you try to hang on for the sake of getting through the process. But what you don't realize, or you fail to accept, is that while you're going through it with this spouse, they don't want to see you get the green card. And this may also go for the parent-child relationship. They will never make, they will ensure you never get to the green card. This going through the immigration process with you is just another way to hold something over your head. When it comes to the interview, they go to the interview and they sabotage your process. They sabotage your process and get purposely, intentionally get you denied because they go, maybe they pretend as if they don't know the answers to the questions. They don't, sometimes they tell lies to the immigration officer if they really want to get back at you. I've seen that before, where they go to the officer and they tell the officer they're really helping you out. This is a bona fide marriage, but they're doing that because they know that they don't want to see you get that status. They want to keep this game going where they can control you while you're without status. Had this had you now decided to pursue the vow process, take control, and apply before getting to that point, you would have been protected to a certain extent. That spouse would have been excluded from the process, and it would be a confidential process. So you wouldn't have to even tell the spouse that you're going through the process, the spouse or relative that you're going through this process to get the green card on your own based on the mistreatment. So don't make the mistake. If I would say this, if you're considering VAWA, it means that you are in that situation. You're listening to me and you're really considering this as an option. It means that you're in trouble and you should make sure that you get in touch. Let's talk about it and confirm you qualify and move forward with your process ASAP, whether you're currently going through the marriage-based process or not. You don't want to delay the process here. Now, another mistake is getting rid of any evidence of your marriage or your bona fide marriage together. So I know you may be separated from that spouse and you just want to put them behind you. So you maybe tear up the documents or you leave the documents behind that show that you shared a lease together, maybe documents showing that your spouse was a citizen or a permanent resident. You just want to get rid of it. So you throw everything out the door and you don't preserve anything. You delete the text messages from your phone, you delete pictures from your phone or from your devices. Document everything. Document everything because that is what's going to be useful to get you your approval. So don't, I know you want to put this person behind you, but make sure if you don't want it in sight, put it somewhere safe that you don't see it, but you know that when it's time to use it, you can for your process. So just make sure that you document everything. If you're in this situation, document everything. Keep your pictures, keep your text messages, keep your joint lease. Make sure you keep any documentation that the spouse or the relative gave to you. Make sure you hold on to those as well. So, those are some of the biggest mistakes that I see in the VAWA process. If you've been through a similar situation, you can tell me about maybe mistakes you've made in the process. You can always share that with us in the comments. I see a lot of questions coming in as well, so I'm going to answer some questions just so we can all learn from them. Oh, so I have a good positive story here, and I'm looking. Thank you so much for the compliment. My son's work permit and travel documents on the way. Supposed to receive it Friday. He's tracking it. God and time, 18 years. I haven't seen him, and I'm crying. Congratulations, and I'm with you on that. That's one of my favorite parts about this is that I get to also help my clients to become unified with their family. And so here is an example of the result of that work permit and travel document. It's not just about getting a job or being able to travel, but what it represents: supporting your family, being with your family, seeing your family, being united with your family. That's also what it's all about. So it is life changing, and thank you for that. I have a VAWA application. They send me notice to do biometrics for I-130, I-360, I-485, but not the I-765. Why is that? And doing the biometrics, what does that mean? So the biometrics is for fingerprinting. Yes, absolutely, Dream Queen of Hearts. 18 years is a long time, definitely. So biometrics is for fingerprinting. It's for your background check. So they do a background check to make sure that your background does not reveal anything that's going to compromise your admissibility to get the permanent residence or the VAWA approval. The I-485 covers the background check for the I-485, covers the I-765. So they usually do the fingerprinting for one, and it usually covers the rest of it. So no worries there. You'll probably still get your work permit after you pass a background check. My application is 8 months old. Attorney didn't select C9 category, but chose C31. Yes, so now on the I-765, yes, so C9 is the correct category. Now, I'm not your attorney, and I definitely, you know, you should definitely speak with your attorney. But C31, so whenever you're applying for a work permit, there are different categories of work permits. So the C9 is usually where you're applying for a work permit while your adjustment of status, your VAWA application is pending. That is the one you need to put. C31 only comes through after the VAWA petition is approved. So that means that if you applied for C31, it's going to sit and wait until you're approved for the VAWA, which is about 2.5 years from now. So you definitely want to fix that or talk to the attorney about fixing that to make clear that it's a C9 category. Because they will go by that category. You'll either get a denial that the VAWA has not been approved yet, so you can't get a C31, because the C31 category is based on an approved VAWA petition. So make sure you follow up on your attorney with that. Yeah, so it's a common mistake, and I'm glad that you brought this up, because the C9 category is for the adjustment of status. The work permit does not come through on if you don't put C9, then they're not going to process that for adjustment of status. They're going to process it for VAWA, an approved VAWA. So I'm so sorry you're going through that, but you definitely need to push back harder on that attorney, or consider whether this is the right attorney for you, because that I have seen denials based on that mistake. I-140 and I-485 were submitted last November, but we still have not gotten a biometrics appointment letter. Would you consider this to be too long to getting a biometrics appointment? May not be. It just depends on where they are on the I-140. I mean, biometrics are I usually get biometrics in about 2 months. So November is kind of long, and you want to check on that, because they may have sent the appointment notice and you may not have gotten it. So you want to check on that for sure, because that is definitely long for an adjustment of status application. You're welcome. All right. The meaning of master hearing, please explain it to me. My court date 11/20/2025 at 900 mark. Okay. So your master calendar hearing, that's usually the first hearing or the initial hearing after you get a notice to appear. So that's where you're going to go and you're going to answer to what I refer to as the charges in the notice to appear. Usually the notice to appear tells you that they have found that you're deportable, and based on specific sections of the INA, you may be deportable, and it just depends on why they find you deportable. And then you would have to either accept or deny, and then also put forth your defense. What is your defense? Are you applying for asylum, cancellation of removal? What is your defense at the master calendar hearing? The judge will then either accept those and then go ahead and schedule the hearings to come after, which is usually the individual hearing. The individual hearing is sort of like the final trial, where the judge is going to consider your pleading. What is it that you're coming forth with as a defense to the deportation, and why should they stop the deportation? The judge may also provide you a schedule, you and your attorney, because this is where you need to have an attorney, because this process is complicated and you want to make sure that they understand you are fully compliant with all the requirements of the court, because the judge may also give you a brief schedule where you would submit your briefs, and you definitely have to make sure you abide by that brief schedule, because the brief is what the judge is going to read to determine whether you qualify for whatever relief you're asking for from the court. So in this time, you need to make sure you have a strategy for how you're going to approach your removal proceedings. If I'm married 2 times in the U.S., is that going to affect my current adjustment of status? It depends on what those 2 previous marriages say about your background. Um, does were they properly terminated? If they were not properly terminated, then yes. Were you married back to back? Does that raise questions? Were you married one after the other very soon? Did you marry this person before right after the 2 previous marriages? Did you file adjustment of status with the other 2 previous marriages? Those may raise some questions. Does emotional abuse from siblings count? And I think you're referring to VAWA. Unfortunately, not for VAWA, but there are other options here. For example, if your siblings subjected you to emotional abuse by also forcing you to work in their homes, take care of their children, work in their businesses, then that can amount to a T status. So you definitely want to speak with me in a consultation to figure out whether you qualify. Threats as well. Let's talk. You had threats, emotional abuse. We have gotten approvals based on this kind of mistreatment, but for T status. How can you assist immigrant that lives in the USA? I assist many of my clients. Majority of my clients are in the USA, living here, and we're working to get them. We're working to get them their status, their work permit, their green card. But whether you qualify is going to depend on what are your individual qualifications. So we need to talk. That's where the consultation is going to be very important. Thanks so much for sharing the live. Do your office assist people who came across the border and are in detention? So we definitely assist individuals, but we have to understand, we have to speak with you to understand how we can help you, how you qualify for that help. My mom's lawyer is withholding my work permit. What do I do? So That's a major problem. So a lawyer is never supposed to hold that especially a work permit. And usually, sometimes I've seen this happen where a lawyer tries to hold on to the person's immigration documents. A lawyer is never supposed to do that for payment. So the lawyer always has to find a mode that does not involve withholding people's documentation. It's unethical, and you may need to um, confront the lawyer. And if you want to report this, you can report it to authorities to see if you can get that work permit, because that should not be the case, and nobody should be holding on to your work permit. She says he says she owes $2,000 for me to be able to get it, but technically he's not my lawyer. So yeah, so there are definitely some ethical issues here. And you definitely can reach out to authorities to see if you can get it, because they are not supposed to hold on to your documents. Do you need 5 years tax return to file for citizenship? Yes, so you want to have that ready. Sometimes they don't ask for it, but you're supposed to file your taxes or show why you haven't, a justified reason why you haven't filed your taxes. So having the 5 years tax returns is going to be necessary, or being ready to answer why you haven't. For example, sometimes if you don't make enough money in a year, you may not have to file taxes, and that's okay. But if you are supposed to file taxes and you didn't, that's going to be a problem. Everything you are saying is a fact. Thanks so much, Pink Diamond, for validating what I was saying. Meaning of prima facie on VAWA case. So a prima facie is basically saying that if they had to make a decision based on the preliminary, the evidence, and based on their preliminary review, your case would be approvable. However, they are going to do a more detailed review. As I said before, remember, they also really double check it for credibility. And so they will double check it, but in the meantime, they give a prima facie that can give you your ID in the state that you're, it depends on the state you're in, but you can get your ID, possibly some types of benefits and assistance. I-130 approved, interview scheduled for I-140, I-485. So yeah, so sometimes that happens. And I'm not sure where you are in the process, but if they have additional questions, they will schedule that I-485. How long does it take when you file for kids? So if you're a citizen, kids are under 21, so up to a year, under a year. If they're 21 or over, it's a 5 to 7 year process. What happens if you want to withdraw your asylum case? So it depends on what's going on here with your asylum and why you want to withdraw it. I'm on a process of FAWA. How long does it take for you to get working permit and travel document? So it can range anywhere from 8 months to 12 months to get that. What to expect when you have an RFE medical request? It means they might, once you send in the medical request, they might very well send the green card in the mail. That's a first hint. I-130 approved last week and interview scheduled. I-485, so I talked about that. So that's true. Thank you for that. Thanks so much for the follows. How likely is a man to get approval of our? So we've gotten multiple approvals for our clients who are men. So I can tell you right now, it doesn't matter. It doesn't matter. They do not discriminate because you're a man. So I would say 100% likelihood that a man will get approval of VAWA. Can you get a work permit while waiting for I-601 through VAWA? Yes. Yep. Absolutely. My clients are waiting for the I-601 and they have their work permit. How long for an I-824 for minors? So it can take up to a year. Good afternoon. I did my N400 in on 3/10/23 on interview, still no decisions, telling me that your case might be a little more complicated than stated. So you definitely need to get legal advice here. How long after divorce can I marry to file for husband? So it depends on, so if you're a permanent resident and you divorce within 5 years of getting permanent residence and you got the green card based on your marriage, then you remarry within the 5 years, they're going to deny that petition. And you have to wait until after the 5 years or until you are a US citizen. How many years can an asylum seeker go for an interview after having working permit and social? So I've seen this go as long as 8 years, 8 to 10 years. I-130-hour fee response sent, USCIS scheduled and canceled interview on Sunday right away. What next? So they'll either reschedule it or maybe they have what they need already and they'll send you the green card. Is it safe to travel on travel document? In most cases, yes. However, I don't just blindly say yes to my clients. I evaluate I know my clients. So when they get the travel document, I know their background, I know the risk that they're facing, and so I can advise them individually on what the risks are, because the risk is not zero, but it's generally safe to travel on the travel document as long as you don't have you don't have those additional risks of being denied entry when you're coming back. I-130 approved, and after interview, I-485 not approved. I-485 not approved for a week now. So I guess it's still pending, and it usually takes them a little, could take a week, it could take a day, could take a week, could take a couple of weeks. So just follow up with them, make sure that they're not asking for anything that you can provide to them, and you'll just have to wait for that decision. Do you qualify for VAWA if you have deportations? Yes, it's still possible, but it depends on, with the deportation, were you deported and then did you re-enter the country? That may have more severe consequences, and we'd have to determine whether you qualify for forgiveness. And then if you're going through deportation, also we'd have to revisit that in the court to address that so that you can move forward with the VAWA process. Do you get notice saying that USCIS received your request for medical evidence after requested? So through the portal, we don't usually get a notice saying that, but we do get it through the portal or through the status check. Can I apply for citizenship after completing my 6-month probation and my case is closed? That's possible. But usually, is the conviction and the probation, even though your probation is closed, is it going to affect your good moral character? Because they're going to look backwards 5 years, in most cases 5 years, maybe 3 years, and if whatever happened occurred within the last 3 years or 5 years, then that can cause a denial. The time on the website is the time they take. It varies. So the time that you're seeing is the minimal and the maximum amount of time. I would say, right in the middle is usually the best, um, the best approach here. Expectation. How can I adjust status? It depends on who your family is. What's your employment? Do you qualify for humanitarian relief? Does prima facie letter protect you from deportation? Not necessarily. I mean, the fact that you're applying for VAWA does offer you a certain level of insulation, but if they really feel the need that you need to go through removal, it's not going to stop that. until you possibly get an approval. But it might cause it, in the same breath, they may see this as evidence that they need to close the case, terminate the case for deportation. So it may, but if they really feel that you need to be removed, then that might not save the day. But this is what I will say: it's best to have something on file than nothing at all. Did my I-130 from November and did my I-130 from November get my receipt, but didn't hear back nothing from USCIS. So yeah, it takes a while. It can take 9 to 12 months to get a decision. How long does it take to get work permit after U visa? A year and a half to 2 years. My VAWA I-131 was approved. That what's next? So now next, probably waiting for the decision on the VAWA. You'll probably get a couple prima facies while you wait as well. I filled for I-589 for asylum. How long it takes for work permit? 150 days to apply, 180-day mark, they will issue that work permit. My dad just started filing for me and I'm over the age of 21. How long will it take? Speak to an attorney. It takes 5 to 7 years. If you're in the US, you're without status, you're going to want to talk to an attorney. All right, so I'm gonna come here now. I'm going from platform to platform just to make sure I get to everybody's questions. Thanks so much for your patience. Hi there, child of God, Mackie. So nice to see you. Now I'm gonna answer questions here. That's the worst mistake ever, is doing it without an attorney. Absolutely, I agree. It's best to get the right attorney to help you through the process. What comes after biometrics for T status? And how long after for approval? So biometrics comes at around, so they're really moving quickly right now. I'm seeing them in about a month to 2 months after receipt notice, more like a month right now. So it's moving fast. Hi, good morning. What if I don't have pictures evidence, but only have memories that happens to me? I often say your memories are enough, because once you have the memories, we can transfer that onto paper. And when we transfer your memories onto paper, it becomes your declaration, and your declaration is accepted as evidence. So it counts here. If you went through it, it counts. Don't discount your experiences. It counts as much as any other type of evidence. But what if you provide police evidence, more than one? Then that's really good evidence. If you provide police evidence for VAWA, then it's good evidence. It's not required, but it is definitely good evidence. Is it a good idea to send in the paperwork before you send in the evidence? So now, if you are facing a filing deadline and you must get this in. So for example, say you divorced your spouse that was mistreating you, and say when you divorce your spouse who mistreated you, you have up to 2 years to apply for VAWA, right? And say a week before the 2 year mark after your divorce, you find out, you did a consultation with me, you found out that you qualify for VAWA, right? But guess what? It's in a week. In a case like that, and guess what? If you miss that filing deadline of 2 years, you get no more chances. You just don't qualify for VAWA anymore. In a case like that, we would definitely prioritize getting it in, right? Getting that petition in with as much evidence as we can, and then supplementing the evidence later, because in that moment, the most important thing is to beat the deadline. Otherwise, the client is disqualified forever. So in that case, yes. But if you have the time, we have the time, we make sure we work on your case and we submit everything at one time, because we find the best results come when we put the best application forth at the forefront when we're able to. What if I don't have pictures evidence but only have memories? I answered that. Went through all of that and still waiting. I'm so sorry you went through that. Having children together is huge credibility. Exactly. So, yes, not everybody has children, of course, but having children together is definitely goes towards the bona fides of the marriage, the fact that the marriage is real. If you live with a person and you're not married, but the person is still physically abusive, do you qualify for VAWA? Give us a call. Because VAWA, no, you wouldn't qualify through marriage, but there is what's called T status. And there are situations where that abuse covers, they're forcing you to do things in the home, they're forcing you to do acts against your will. That does amount to qualifications for the T status if you feel like you're being forced to stay in that situation. Yes, I underestimated it at first because I did not know about it. So I'm so sorry that's the case. Um, Sooner is better because it takes years to get approved. Absolutely. Yes. That's another thing. I'm glad you brought this up, Dream Queen of Hearts. The sooner the better for VAWA. You avoid complications, and the sooner you apply, the sooner you get the benefits of the VAWA process. Because you'll be going through it for a while, but you do get the benefits while you wait. Good day. After submitting documents for I-212, how long does it take to get a notice? So it's supposed to be two weeks, maybe if they're really busy, 4 weeks. Um, yes, still have all my evidence from years ago. So I'm so glad that you're affirming everything that I talked about. So whenever, and this again goes to the VAWA, and what you should make sure you do is preserve, document everything, and save it, no matter how long ago that documentation is there for. How long does it take when removing your 2-year green card? So 2 years to up to 4 years. They're giving 4-year extensions because it can take up to 4 years, but on average, it's taking about 2 years, and which is so frustrating. How long after employer abuse do you have to apply for T visa? Right away. You can't apply. There's nothing that says you can't apply. You have to apply a certain amount of time afterwards. In some cases, for my clients where they're currently in that situation, trapped in that situation, we are going for relief for them, and they're still in that situation. But this is the lifeline. The immigration status is their lifeline to escape it. So there's no timeline. Apply as soon as you know you qualify. How long is the process for the travel document after the T visa is approved? So travel documents can take anywhere from 6 months to 12 months. If you have an emergency, if you apply for an emergency travel document, you could get it within a month. They denied my I-485. It was submitted with my I-360 application, but I don't know why. So give us a call. Let's talk, because you definitely need to understand what is going on here. Now, one thing is it can make a difference based on whether you're married to a permanent resident or married to a U.S. citizen. If you're married to a permanent resident, it may not be time to apply for the I-485 yet. You have to go on a wait list first. So that may be where the problem is. C9 category work permit. So yes, C9 is now, when applying for VAWA, you need to make sure that you have the right, and you're applying for VAWA with the work permit adjustment of status, make sure you have the right category, because they will deny it based on wrong category. Yes, so a brilliant attorney, she basically gave us a class to learn the whole process of our application. Thanks so much. That's right. I am really giving you guys some pearls here. How long after they give you the green card? When they give you your work permit. So your work permit comes before the green card. So the green card depends on what you're applying for, but the work permit comes a few months to up to a year after you apply for your green card. Then you get to work on your work permit while they process the green card. My friend goes on a K-1 visa and didn't get married to the person. 10 years later, he got married to a USC, submit I-130, was approved. He lives in the US. The case sent to NVC. Should he just file adjustment? So I'm so glad you brought this scenario up. Once you come on a K-1 to marry somebody, the K-1 is a fiance visa. You come to marry somebody, but you don't marry them, and you end up overstaying that K-1 visa, you don't return, then guess what happens? A very terrible consequence happens. You are not allowed to go through adjustment of status. Even if you get married a second time and you try to do adjustment of status, they will not allow it. So this is where it's very important. And keep in mind that that covers VAWA as well. Unless you don't marry the fiance because they're abusive, then of course VAWA does not cover fiancés, by the way. You'd still have to get married to that person first and then apply for VAWA. So if you never marry them, you move on, they will not allow you to do adjustment of status. So that is one of the terrible repercussions here. Now, if you did not get married, and this is for everybody married, you are on the K-1, didn't get married because of abuse or mistreatment, let's talk about possible alternatives like the T status. If you were forced to do acts that you did not want to do, or labor that you didn't want to do, that includes work in the house that you didn't want to do. Good day. After applying, here's an example. You get sponsored on the K-1 fiance visa. You're happy, you come here, you think you've met the love of your life, you're going to live your life happily in the United States with your fiance turned spouse. But when you get here, your spouse has a disabled child or a disabled parent in the home, and you find out now that this person, the motive of them sponsoring you on the K-1 fiance visa was basically for you to come and take care of their child or their disabled parent or something similar, do some kind of work for them to their benefit. Their true goal was never to marry you, or even if they marry you, they marry you, the real goal is to mistreat you, force you to do things that you really didn't sign up for. That can qualify you for T status, because what they did in essence is to traffic you to the United States on the K-1 for their own purposes, right? To either have you work in their business, work in the home, work for their disabled parent or child or any other relative. So give me a call, let's talk. Because if you face a situation like that, the alternative would be the T status. I've been married to a US citizen for over 2 years and want to file. Now, what form should I use? So if you're going from the 2 year to the 10 year, then it's going to be the I-751. I also living in the US, got married in the US. All right. Want to get citizenship. I'm a student visa now. So you don't go from student visa to citizenship, and keep in mind, citizenship is very different from residence. You have to be a resident before you become a citizen. There's no straight path from student visa to permanent resident. This is where you have to explore your employment options, your family options, your humanitarian options to determine whether you qualify. Do you have to have a therapy report for VAWA? Nope. I've gotten approvals without a therapist evaluation. How to get citizenship while on student visa. So you need to talk to us and we can see what you qualify for. What happens if someone marries a US citizen after T status approval? Nothing. You still get to move forward with your T status, become a green card holder based on your T status. Now, if you got T status, now T status has a great benefit. And the great benefit is, say you came in EWI, you came in without inspection, and you applied for a waiver to get forgiveness for the way you entered the United States. And say you got approved for your T status. You can then take that T status and the approved waiver and apply for the green card on the T status, and it will not be used against you. But say you got married to your US citizen and you decided to go through the marriage based process, then they're still going to use that EWI entry against you in that green card process through your spouse. So whether you choose to go through your US citizen spouse or continue through the green card based on your T status is really based on the circumstances here and which one offers the most advantage to you. How can I get to your law firm? So go to the link in the profile and you will see the link tree. You'll see a number of options, buttons. You can click to look at the website. There's a number there. I believe the number is on our profile page too. So you can always call. There'll be somebody answering. You can DM us as well, and we'll take your information, get in touch with you. You can go ahead and schedule your own appointment. That's the most important one. And it's the one to get to me the fastest because you get to choose my schedule or Attorney Bria's schedule. Attorney Bria works closely with me to determine whether you qualify for us to help you for work permit or status here or green card. So you have many simple options to get through to us. And you can schedule your own appointment. That's going to be the best way. My friend goes up on a K1, didn't, okay, I answered that one. How long does it take to get your green card after you get your work permit? Okay, so after you get the work permit, so it depends. It really depends on what you're applying for. Thank you for your time and answers. I know everyone here is beyond grateful. Thank you so much. I enjoy this. I usually plan to be here for 30 minutes, but whenever I do have the extra time, I really love your questions. I end up staying a little longer. So thank you for that. I appreciate that. If I-751 is still pending and then get a divorce, will that affect the current application? Yes, I'm glad you brought this up. Very important to know because this is a very big mistake with the I-751 process. I-751 process is where you're going from the 2-year to the 10-year. You're removing the conditions on your green card. Now, if you get a divorce and then you do not inform them about the divorce and they either approve your green card, right, without you informing them about the divorce, then you'll face problems and possible accusations of fraud at citizenship stage where you're applying for citizenship. Or if they call you in for an interview and you go into that interview without applying for a special waiver to tell them you're now applying by yourself, they're going to deny your application because they're going to have the expectation that your spouse should be present unless you submit a waiver. So you need to make sure that that waiver is in ASAP. And we do this for our clients. We do submit the I-751 waiver. So make sure that you talk to us about that. I-130 brothers, sisters terminated by NVC for failure to respond. Can I still apply through 245I even if I'm qualified? It may be a possibility depending on when those previous petitions were filed. Were they filed on or before April 30th, 2001? Good day. After applying for an I-212, how long? So I answered that. How long does it take to be approved for the I-131? So I'm seeing 6 months to 12 months, especially if you're applying for the travel document by itself. If you have an emergency, though, you can apply for an emergency travel document, and that can be issued within about a month. All right, I'm going to answer one more question that I see here, and then I have to head out. But, of course, follow me, subscribe. And when I come on, you'll see when I'm on, and you can come on with your questions again. And once I get a steady schedule going, then I'll let you know that predictable time. But in the meantime, please just go ahead, follow, subscribe, and then you'll see when I am live, so you can answer. I have a prima facie determination. What's next? I'm not applying for green card, just I-360. How much do I have to wait for approval? So the I-360 is taking about 2.5 years to be approved. The prima facie, in the meantime, can help with some benefits and relief, like your driver's license, state ID, but it depends on the state you're in. All right. Thanks so much, everyone. Now, if you want to get on my schedule, go to the link in the bio on TikTok and on Instagram. On YouTube, Facebook, look in the description of the video, the content in the description of the video. You'll see the link to Linktree. Click on the link, then you can schedule your appointments. My schedule is filling up very fast, and so is Attorney Bria's. So please make sure that you do that fast, and make sure you do it fast, because you'll be surprised how quickly the schedule fills up. We're looking forward to helping as many people as possible. That's my mission, and that's why I do this. So if you need this help to get your status here, even if you're undocumented, even if you overstayed, we can help you. We've helped many clients, and we're going to be here for you as well. So give us a call, schedule your consultation, or both, and we'll be more than happy to help you. Have a great day, everyone. Bye bye.